The sheriff's deputy had one hand resting on his belt when the HOA president pointed at me and said, "I want him removed from the vineyard. Now." For a second, nobody moved. Not the deputy, not the two private security guards standing beside the tasting room entrance, not the dozen tourists who had stopped drinking their wine to watch, and definitely not me. I was standing between two rows of Cabernet vines outside Sonoma Ridge Winery in California, staring at a woman named Patricia Caldwell, as if she had just lost her mind. "You're trespassing," Patricia said. I looked down at the dirt beneath my boots, then back at her. "On what property?" Her mouth tightened. "This vineyard is controlled by the Ridgeview Estates Homeowners Association." "No, it isn't." Patricia gave a short laugh and turned toward Deputy Mark Ellison. "You see what I've been dealing with?" The deputy studied me carefully. "Sir, do you have identification?" I pulled out my wallet. Patricia stepped closer before I could hand it over. "Identification doesn't matter. We issued him a formal exclusion notice 3 days ago." She held up a document stamped with the Ridgeview Estates HOA logo. "He was told not to return." I felt every eye on me. Behind Patricia, one of the security guards reached toward my arm. "Don't touch me." He stopped. Patricia's expression hardened. "You were given an opportunity to leave peacefully. This land doesn't belong to your HOA." "It absolutely does." "Then show me the deed." That changed her face, only slightly, but I saw it. Her eyes flicked toward the security guards, then toward the deputy, finally back to me. "We are not conducting a property hearing in the middle of a vineyard. You're trying to have me arrested in the middle of one." Deputy Ellison raised his hand. "Everybody calm down." Patricia immediately pointed toward the gravel road. "Deputy, I'm requesting a formal trespass removal." He looked at me. "Sir, until ownership can be clarified, I'm going to ask you to step off the disputed area." The words hit harder than I expected. Disputed area. My grandfather had walked those rows. My father had repaired the irrigation lines beneath them, and now I was being escorted away like a stranger. I took 3 steps toward the road when a voice thundered from behind us. "Deputy!" Everyone turned. A black pickup had stopped near the winery building. A tall man in his early 60s climbed out and slammed the door. I recognized him immediately. Thomas Whitaker, owner of Sonoma Ridge Winery. Patricia suddenly looked uneasy. Thomas walked straight through the crowd carrying a thick leather folder. "What exactly is happening here?" Patricia recovered quickly. "Thomas, this is an HOA matter." "No," he said. His voice was quiet now. "That's exactly what it isn't." He stopped beside me. Deputy Ellison gestured toward Patricia's paperwork. "She claims this gentleman is trespassing on vineyard property controlled by Ridgeview Estates." Thomas stared at Patricia for several long seconds. Then something almost like disbelief crossed his face. "You told the sheriff this vineyard belongs to your HOA." Patricia folded her arms. "Our attorney has already established control of parcel 17. Thomas slowly opened the leather folder. The vineyard went completely silent. He removed an old certified document and handed it to Deputy Ellison. "Then your attorney should have checked the county recorder's office." Patricia leaned forward. "What is that?" Thomas didn't answer her. He looked directly at me. Then he pointed toward the document in the deputy's hands. "That is the recorded deed for parcel 17. Deputy Ellison read the first page. His eyebrows pulled together. Then he looked at me. "Sir." Patricia stepped closer. "What does it say?" Thomas finally turned toward her. "It says you just had a man removed from land that doesn't belong to your HOA." Patricia went pale, but Thomas wasn't finished. He tapped one name printed on the deed. "And it doesn't belong to my winery either." His eyes returned to me. "It belongs to him. My name is Daniel Mercer. I'm 54 years old, and for most of my adult life, I've worked as an agricultural irrigation contractor in Sonoma County, California. I'm not a lawyer. I'm not a developer. And until Patricia Caldwell entered my life, I had never attended an HOA meeting. The land she tried to throw me off had been part of my family for 3 generations. My grandfather, Walter Mercer, bought 28 acres outside Healdsburg in 1968. Back then, there were fewer luxury homes, fewer tasting rooms, and definitely fewer people arguing about what color somebody's mailbox should be. He planted grapes on 12 acres. The western portion remained pasture and oak trees. When my father inherited the property, he eventually leased the vineyard acreage to Thomas Whitaker's family winery. That arrangement lasted decades. Thomas maintained the vines. His winery harvested the grapes, and our family retained ownership of the underlying land. When my father died 9 years ago, the property passed to me. I kept the lease because Thomas had always treated my family fairly. Every October, I would walk the vineyard after harvest, inspect drainage channels, check fencing, and usually end up drinking coffee with Thomas behind the winery. Life was quiet. Then Ridgeview Estates appeared. A developer bought 60 acres bordering my eastern property line and built 43 expensive homes overlooking the valley. Within 2 years, Patricia Caldwell became HOA president. I first met her when she left a laminated notice on my gate, unapproved agricultural equipment visible from community property. I actually laughed. My tractor was parked inside my own equipment shed. I called the number on the notice. Patricia answered. Ridgeview Estates HOA. This is Daniel Mercer. Someone put a violation notice on my gate. Yes, I authorized it. I'm not in Ridgeview Estates. There was a pause. Your property directly affects our community's visual standards. That's not the same thing as belonging to your HOA. She sighed as though I were being difficult. Mr. Mercer, cooperation benefits everyone. I removed the notice and forgot about it. Then another arrived. This one complained about Vineyard machinery operating before 8 in the morning. Thomas received one too. After that came complaints about harvest trucks, dust, irrigation pumps, and workers using the Vineyard access road. Then, one Tuesday afternoon, I noticed something that didn't belong. A new metal sign had been driven into the ground beside the vineyard entrance. Ridgeview Estates, Private Community Agricultural Preserve. I pulled it out myself. The next morning, it was back. But this time there was something else attached to my gate, a certified legal notice. According to the document, Ridgeview Estates claimed Parcel 17 had been incorporated into the HOA's Community Preservation Boundary under an old land use agreement. And at the bottom was a sentence that made my stomach tighten. Unauthorized entry onto Parcel 17 may result in removal and prosecution for trespassing. I read it 3 times. Then I looked through the gate at the vineyard my grandfather had planted. Something was terribly wrong. I called Patricia Caldwell that afternoon. She answered on the 4th ring. Ridgeview Estates, HOA. This is Daniel Mercer. I'm standing in front of another notice you put on my property. Her tone changed immediately. Mr. Mercer, I was expecting your call. You're threatening to prosecute me for entering my own vineyard. Parcel 17 is no longer considered your private agricultural property. I actually pulled the phone away from my ear. What did you just say? The HOA's attorney reviewed the recorded land use documents. Parcel 17 falls within Ridgeview's preservation boundary. A preservation boundary doesn't transfer ownership. That's not what our counsel advised. Then your counsel needs to read my deed. Patricia went quiet. Then she said, perhaps you should attend Thursday's board meeting. So I did. The Ridgeview clubhouse looked more like a boutique hotel than a neighborhood meeting room. Patricia sat behind a long walnut table with 4 board members and a man in a grey suit. She introduced him as Gregory Shaw, the HOA's attorney. I placed copies of my deed and property survey on the table. My family owns Parcel 17. Gregory barely glanced at them. We're familiar with your claim. My claim? Patricia leaned forward. Daniel, nobody is trying to erase your family history. Then stop putting trespassing notices on my gate. Gregory opened a folder. In 1996, Walter Mercer signed an agricultural preservation agreement with the county. That was my grandfather. Correct. That agreement restricted development and established permanent agricultural use. I know what it did. Gregory slid another document toward me. Ridgeview Estates subsequently acquired enforcement authority over the preservation corridor. I read the first page. It talked about landscaping, agricultural buffers, drainage access, and preservation standards. Nothing about ownership. Nothing about excluding me. I pushed it back. This doesn't give your HOA my land. Patricia's smile disappeared. It gives us administrative control. No. It gives you responsibilities near the boundary. Gregory closed his folder. Mr. Mercer, continuing to enter disputed property after receiving formal notice may complicate your legal position. I stared at him. Was that legal advice or a threat? Nobody answered. 3 days later, 2 Ridgeview security guards appeared while I was checking an irrigation valve. One stepped between me and my truck. Mr. Mercer? Yes. You've been formally excluded from this parcel. Move. He held up his phone. We've been instructed to document any unauthorized entry. I looked toward the Winery building. Thomas was away at a distributor conference in Oregon. Perfect timing. Call Patricia, I said. Tell her she has 5 minutes to get these men off my property. The taller guard shook his head. We have our instructions. Then a white Range Rover came down the access road. Patricia stepped out wearing sunglasses and carrying another envelope. This needs to end, Daniel. She handed me a cease and desist letter. You are interfering with HOA-controlled agricultural property. I tore open the envelope. The letter accused me of harassment, unauthorized access, disruption of vineyard operations, and intimidation of HOA representatives. I looked up slowly. You're building a paper trail. Patricia removed her sunglasses. We're documenting your behavior. No, you're manufacturing a dispute. Her jaw tightened. If you enter parcel 17 again, law enforcement will be contacted. I stepped closer. My grandfather bought this land before your subdivision existed. And times change. Deeds don't. She smiled. We'll see. The next morning, I found orange survey stakes running along the Vineyard Road. Then an email arrived from Gregory Shaw. The HOA intended to install a permanent access gate and assume exclusive management of parcel 17, pending title clarification. That was when I finally understood. This wasn't about vineyard noise. It wasn't about appearance. And it wasn't about preservation. They were preparing to take control of the land before I could stop them. I called Rebecca Sloan before I called anyone else. Rebecca was a real estate attorney in Santa Rosa who had handled the probate work after my father died. She knew the Mercer property almost as well as I did. When I finished explaining what Ridgeview was doing, she stayed silent for several seconds. Then she said, "Send me every document they gave you." By noon the next day, I was sitting across from her in a conference room. My deed was on the table. So was the 1996 Agricultural Preservation Agreement, Gregory Shaw's cease and desist letter, and the document claiming Ridgeview had enforcement authority. Rebecca read the last one twice. This is interesting. What? They keep using the phrase, administrative control. That's what Gregory said. She tapped the document. But this agreement doesn't grant exclusive possession. It certainly doesn't transfer title. Then how are they claiming they can remove me? That's what I want to know. She opened her laptop. For the next hour, we worked backward through county records. My father's transfer to me was clean. His inheritance from my grandfather was clean. Walter Mercer's original 1968 purchase was clean. Parcel 17 had never been sold separately. Then Rebecca found something. Daniel. She turned the screen toward me. A document had been recorded 18 months earlier. Assignment of agricultural management rights. The grantor was listed as Sonoma Ridge Winery. The recipient was Ridgeview Estates, HOA. I stared at the screen. Thomas never mentioned that. Rebecca frowned. This supposedly assigns Ridgeview broad management authority over parcel 17. Can a tenant even do that? Not without rights granted under the lease. We pulled my family's winery lease. Page 14 settled it. Sonoma Ridge could cultivate, harvest, maintain irrigation, and access the vineyard for commercial operations. It could not transfer management authority to a third party. Rebecca leaned back. So either Thomas signed something he had no authority to sign, or he didn't sign it. I called him. Thomas answered from Oregon. When I read the document title, he interrupted me. I never signed anything with Ridgeview. Rebecca and I looked at each other. Thomas, there's a recorded assignment with your name on it. That's impossible. It has a signature. Then somebody put my name on something. The room suddenly felt colder. Thomas promised to return the following afternoon. Meanwhile, Rebecca contacted a title examiner named Samuel Price. By evening, Samuel had traced every recorded instrument connected to parcel 17. At 7:40, he emailed us a scanned copy of the original assignment. Rebecca enlarged the signature page. Thomas Whitaker's name appeared above a notary stamp, but Samuel had noticed something else. The document claimed Thomas signed it on March 18th. Rebecca pulled up another county filing recorded that same week. Then she froze. What? She pointed at the notary acknowledgement. Look at the commission number. I didn't understand. She searched the California notary database. The number belonged to Elaine Porter. Her commission had expired 11 months before the alleged signing. Rebecca stared at me. That notarization was invalid when this document was supposedly executed. My phone rang. Thomas. I answered immediately. His voice was tight. Daniel, I found something in our office archive. What? An email from Patricia Caldwell. When? 2 weeks before that assignment was recorded. I put him on speaker. Thomas continued. She offered to buy the winery's lease rights to parcel 17. Rebecca leaned toward the phone. And what did you tell her? I told her no. A pause. Then she wrote back. Thomas inhaled slowly. She said Ridgeview would obtain control of the vineyard with or without my cooperation. Rebecca and I looked at each other. For the first time, this didn't look like an HOA misunderstanding. It looked deliberate. And someone had created a recorded document to make it happen. Thomas Whitaker walked into Rebecca's office the next morning, carrying a battered leather file box. He set it on the conference table. Everything involving the Mercer Vineyard for the last 15 years. Rebecca pulled out the recorded assignment. Before we do anything else, I need you to look at this signature. Thomas studied it. His expression changed immediately. That's not mine. You're certain? I've signed thousands of contracts, purchase orders, distribution agreements. That looks like someone traced my signature. He opened the file box and produced the original Vineyard lease. Rebecca placed Thomas's genuine signature beside the disputed one. Even I could see the difference. The capital T on the recorded assignment curved unnaturally. The final stroke in Whitaker stopped abruptly. Rebecca sent both documents to a forensic document examiner. Then Thomas opened his laptop. I also brought Patricia's emails. The most important one was dated March 6th. Patricia had written, "Ridgeview requires permanent control of Parcel 17 to complete the community vineyard corridor and planned residence pavilion." I read it again. Residence pavilion? Thomas nodded grimly. They wanted to turn the vineyard into an HOA amenity. Another attachment showed a conceptual site plan, a tasting terrace, walking paths, private event space, and a gated entrance connecting directly to Ridgeview Estates. Across the bottom were 3 words. Phase 2. Expansion. Rebecca stared at the rendering. This is motive. By afternoon, we had something even worse. The forensic examiner called. The signature on the assignment showed strong evidence of digital reproduction, not merely imitation, reproduction. Someone had likely copied Thomas's signature from another document. Rebecca immediately prepared a demand for preservation of Ridgeview's emails, computers, board records, and communications with Gregory Shaw. That was when Patricia panicked. At 6:20 the next morning, my phone started buzzing. Thomas. Daniel, get to the vineyard. What happened? They're installing the gate. I was there 12 minutes later. A contractor's truck blocked the access road. 4 workers were setting steel posts into freshly drilled holes. Patricia stood beside them with Gregory Shaw and 2 security guards. I got out of my truck. Stop the work. Patricia didn't even turn around. You're violating the exclusion order again. There is no court order. Gregory stepped forward. Mr. Mercer, I strongly suggest you leave. I held up my phone. You mean before I photograph you building a gate on land your client doesn't own? His face tightened. Patricia pointed toward security. Remove him. Neither guard moved. One glanced toward my phone. Smart man. Then another vehicle came down the road. Rebecca. She stepped out holding a thick envelope. Gregory. He looked at her. Rebecca Sloan. She handed him the envelope. You and your client are now on formal notice to preserve all records relating to Parcel 17, including the apparently fraudulent assignment recorded 18 months ago. Patricia's face drained. Fraudulent? Thomas arrived behind her. He walked directly toward the construction crew. I never signed that assignment. Nobody spoke. Thomas turned to Patricia. And you knew I refused to give Ridgeview control. For 1 second, Patricia looked genuinely frightened. Then anger took over. You have no idea what you're accusing me of, Rebecca answered calmly. We know exactly what we're investigating. Within an hour, the contractors packed up. But Patricia had one final move. That afternoon, Ridgeview emailed all 43 homeowners, claiming I was attempting to seize protected community vineyard land. By evening, people were posting my photograph online. Trespasser, land thief, extortionist. I sat at my kitchen table reading the comments until Rebecca called. Stop looking at them. She's making me the criminal. Let her. I went silent. Rebecca continued. Because tomorrow morning, we file for an injunction, declaratory relief, damages, and an order compelling production of their records. I looked through my window toward the vineyard. Patricia wanted a public fight. Now she was getting one. Only this time, we were bringing the deed, the forged assignment, Thomas's emails, and her development plans into a courtroom. 3 weeks later, I sat beside Rebecca in Sonoma County Superior Court, while Patricia Caldwell watching us from across the aisle. She looked different without the sunglasses and security guards, smaller. But Gregory Shaw still carried himself like the outcome was already decided. When Judge Eleanor Hayes entered, everyone stood. She began with the simplest question. Who owns Parcel 17? Gregory rose. Your Honor, Ridgeview Estates does not claim conventional fee ownership. The association maintains that recorded agreements grant it exclusive administrative and preservation authority. Rebecca stood. Authority so exclusive that they called law enforcement to remove the actual owner. Judge Hayes looked over her glasses. That concerns me. Rebecca placed the certified deed into evidence. Walter Mercer purchased parcel 17 in 1968. My father inherited it. Then I inherited it. No sale. No transfer. No conveyance to Ridgeview. Gregory tried to redirect the argument toward the agricultural management assignment. That was when Rebecca called Thomas. He took the witness stand and identified himself as the owner of Sonoma Ridge Winery. Rebecca displayed the assignment. Mr. Whitaker, is that your signature? No. Gregory stood. Objection, the witness is not a handwriting expert. He's an expert on whether he signed his own name. Judge Hayes replied. A few people in the gallery shifted. Rebecca continued. Did you authorize Ridgeview Estates to manage parcel 17? No. Did you ever have authority to transfer ownership of parcel 17? Absolutely not. Then came Patricia's emails. Thomas read aloud the message where she demanded permanent control for Ridgeview's proposed Vineyard corridor. Rebecca displayed Patricia's response after Thomas rejected the offer. Ridgeview will obtain control with or without winery cooperation. Judge Hayes stared at Patricia. Gregory whispered something to her. She didn't answer. Next came the forensic document examiner. He explained that Thomas's purported signature on the assignment showed characteristics consistent with digital reproduction. Then Rebecca introduced the notary records. Your Honor, the assignment states it was notarized by Elaine Porter on March 18th. She handed a certified record to the clerk. Ms. Porter's commission expired 11 months earlier. Judge Hayes turned toward Gregory. Counsel? Gregory stood slowly. We were not involved in preparation of the underlying assignment. Patricia snapped her head toward him. Rebecca noticed. So who gave you the document? Gregory hesitated. Mrs. Caldwell provided it. The courtroom became completely still. Patricia leaned toward him. Gregory. Judge Hayes immediately spoke. Mrs. Caldwell, do not communicate with counsel while he is answering. Rebecca approached the witness table. Mr. Shaw, when did you first learn there might be a problem with the assignment? Gregory swallowed. After Mr. Mercer challenged the HOA's authority. And yet your office sent him a cease and desist letter. Yes. Did you verify title first? No. That answer landed hard. Then Rebecca introduced the Phase 2 expansion plan. The rendering appeared on the courtroom monitor. Walking trails, a tasting terrace, private event space, a gated connection to Ridgeview. Judge Hayes studied it. So the association was not merely preserving agricultural land. Rebecca shook her head. They intended to convert my client's property into a private amenity. Gregory stood again. That plan was conceptual. Rebecca turned toward Patricia. Then perhaps Mrs. Caldwell can explain the invoice. Patricia froze. I had never seen the document before. Neither, apparently, had Gregory. Rebecca handed it to the clerk. It was a payment from Ridgeview Estates to a private document processing consultant, dated 4 days before the fraudulent assignment was recorded. The description read, Parcel 17, execution correction and signature integration. Judge Hayes stopped writing. She looked directly at Patricia. Mrs. Caldwell, I strongly suggest you consult counsel before answering any further questions concerning that document. Patricia's face had gone white. Rebecca sat beside me. What is that invoice? I whispered. Her eyes stayed on the judge. The reason Patricia is about to have problems much bigger than an HOA lawsuit. Judge Hayes called a recess, but before leaving the bench, she ordered that the disputed assignment, invoice, and related records be preserved for referral to the appropriate authorities. Then she looked across the courtroom. When we return, I will rule on ownership and the association's claimed authority over Parcel 17. Patricia stared straight ahead. For the first time since this began, she wasn't threatening me. She was waiting for the verdict. 27 minutes later, the courtroom doors opened again. Patricia returned with Gregory, but they no longer sat close together. When Judge Hayes took the bench, she spent several seconds arranging the documents in front of her. Then she looked at me. The chain of title is not complicated. My hands tightened beneath the table. The evidence establishes that Parcel 17 was purchased by Walter Mercer in 1968, passed through the Mercer family, and is presently owned by Daniel Mercer. I closed my eyes for half a second. Rebecca touched my arm. Judge Hayes continued. There is no credible evidence that Ridgeview Estates acquired title to this property. Patricia stared down at the table. The judge then addressed the preservation agreement. It restricted development. It protected agricultural use, but it did not transfer ownership, grant Ridgeview exclusive possession, or authorize the HOA to exclude me from my own land. The association's interpretation, Judge Hayes said, was not merely aggressive. Based on the evidence before this court, it was unsupported. Then she reached the assignment. Her voice became colder. The purported assignment from Sonoma Ridge Winery presents significantly more serious concerns. She reviewed Thomas's testimony, the forensic findings, the expired notary commission, Patricia's emails, and finally the invoice referencing signature integration. Gregory rose. Your Honor, my firm wishes to clarify. Sit down, counsel. He did. Judge Hayes granted our request for declaratory relief. She issued a permanent injunction prohibiting Ridgeview Estates, its board, employees, security contractors, or agents from interfering with my lawful access to Parcel 17. The HOA was ordered to remove every sign, stake, notice, and unauthorized improvement it had placed on my property. Then came damages, attorney fees, survey costs, lost vineyard operations caused by access disruptions, and compensation connected to the HOA's wrongful interference. The exact total would be finalized after additional submissions, but Ridgeview's insurer was formally placed on notice. Patricia finally looked at me. There was no smile this time, but the judge still wasn't finished. The court will forward copies of the disputed assignment and supporting evidence to the Sonoma County District Attorney and other appropriate agencies for review. A murmur moved through the gallery. Patricia whispered something to Gregory. He shook his head. Outside the courthouse, 2 local reporters were waiting. I didn't give them much. This was never about destroying an HOA, I said. It was about proving that an organization doesn't gain ownership simply because it keeps repeating that it has authority. Thomas stood beside me. Within days, Ridgeview homeowners began demanding records from their own board. 3 board members resigned. An emergency meeting was called. Patricia was removed as president by a membership vote, while the investigation into the recorded assignment continued. Gregory's firm withdrew as HOA counsel. Weeks later, Ridgeview formally acknowledged in writing that Parcel 17 belonged exclusively to me, and that the association possessed no ownership or access rights. The first thing I did afterward was replace their metal sign. Thomas helped me drive 2 wooden posts into the ground beside the vineyard entrance. We attached a simple plaque. Mercer Family Vineyard, aced at 1968. Thomas stepped back and smiled. Looks better. Much. We stood there quietly as the evening sun stretched across the vines. For weeks, Patricia had made me feel like an intruder on land carrying my own family's history. Now there were no security guards, no violation notices, no threats. Just rows of vines moving gently in the California wind. Thomas looked toward me. Your grandfather would have fought them too. I smiled. He probably would have charged them for the sign they put in his dirt. Thomas laughed. And for the first time since this whole mess began, so did I. 6 months later, the vineyard looked exactly the way it had before Ridgeview Estates decided it belonged to them. And that was the best part. No private HOA signs, no orange survey stakes, no security guards waiting beside the access road, just 12 acres of vines, morning fog rolling across the valley, and the old wooden plaque Thomas and I had installed beside the gate. Mercer Family Vineyard, aced in 1968. Sonoma Ridge Winery continued leasing the vineyard from me under the same agreement our families had honored for decades. Thomas and I also added something new. Inside the winery, we framed a copy of my grandfather's original 1968 deed. Not because I wanted to brag about winning, because I never wanted anyone to forget what nearly happened. Ridgeview eventually elected an entirely new board. The new president called me personally. Mr. Mercer, I know an apology doesn't undo what happened. No, I said, but it's a good place to start. They removed every remaining claim involving Parcel 17 from their community documents and adopted new rules requiring independent title verification before the HOA could make any future property rights claim. As for Patricia, the investigation into the fraudulent assignment continued after she was removed from the board. Whatever consequences followed would be decided by the proper authorities. I stopped caring about revenge. I already had what mattered. My land, my name, and the truth. The experience taught me something I wish more property owners understood. Confidence is not authority. A threatening letter is not a deed. A board vote does not erase recorded ownership. And when someone tells you they control your property, don't assume they're right simply because they have an attorney, security guards, official-looking paperwork, or an HOA logo behind them. Ask questions, read everything, keep records, and know exactly what you own. If you've ever dealt with an HOA that crossed the line, tried to control your property, or acted like its rules were more powerful than the law? Tell me your story in the comments. And here's the question I want to leave you with. What would you have done if someone called the sheriff and tried to throw you off land your family had owned for generations? If you enjoyed this story, hit like, subscribe, and turn on notifications for more property disputes, HOA conflicts, and stories where the truth finally gets its day in court. Thanks for watching, and remember, sometimes the most powerful thing you can carry into a fight isn't anger, it's the deed.